Morning, everyone. Welcome to Volkswagen's first compliance forum for the year 2023. As many of you will know, I'm Chris Finney. I'm a partner in the non-contentious financial services regulatory practice of Volkswagen's. I'm joined this morning by my partners from our contentious practice, Peter Wright, Sona, Ganatra, and our legal director, Sebastian Sayer. They're going to take you through this morning an overview of what's been happening in the PRA and FCA enforcement world over the last year or so, and have a look at what they think is likely to happen in the coming year. If you've got any questions, please submit them through the Q&A function. We'll take as many as we can at the end of the session, and if we can't cover them all, we'll try to follow up directly afterwards where we can. The only other thing I just need to mention before we start is that the session is being recorded, and that we hand over then Peter to start the session.
Thank you, Chris, for that introduction, and good morning, everybody. It's one of these things, I think this is either our second or third time that we've done a sort of annual review of enforcement activity in the FCA and PRA for regulated firms. And it's always interesting just taking a little bit of time in the new year, just to look back to see how the regulators have performed and sort of their impact on the market, and also what that might tell us about the future. And it's also quite interesting for us when we do these sessions, because there's always an element of look back, but then there's the other element of crystal ball gazing and giving you our predictions and actually then seeing out if they turned out to be right from the previous year. And I think last year we were predicting activity in a number of areas, which I think we've seen. So, for example, one of them is continued pension selling, and there's been an awful lot of that. It will come back to that. But I think perhaps one of the things, we weren't necessarily correct on is actually the level of outputs that we may see. So in my section today, it might have a slightly sort of top of box type feel and see where activities have gone up, where things have gone down, and just to give you that little bit of an oversight. So if we move on to the next slide, please. So we've got those aspects. How have we done? What's the regulator focusing on, and what can we learn from that? And then I think a little bit more of the crystal gazing will actually come from Seb in their section. So if we move on to the next slide. But one of the things we've doing these look backs, though, is when you're trying to assess performance of regulators, it's not the easiest of things to do because the amount of data that one has is relatively limited. There's information you get from the regulators from themselves from time to time. Firms such as ourselves do a bit of market research and analysis. I know Chris in the past has made various FOIA requests from the FCA and the PRA to get an idea of their activity levels in various areas. And then we're often very reliant upon, one, what the FCA and PRA are saying in terms of their own enforcement level and activity in the speeches that they make during the course of any given year. When it comes to sort of hard data, though, some of our best sources are from the FCA itself in terms of their annual reports where they have an enforcement performance account, and also tracking what happens in terms of true enforcement outputs, so final notices from the FCA and also the PRA. I will make reference a little bit later to some PRA enforcement action, which is really novel or a little bit more than we've ever seen in the past. But a lot of the data that we get comes from the annual report, and this is sort of midpoint of year information. Now, one of the things that you can also track on a sort of soft basis is how the FCA's tone in tenor changes in its annual report. If we went back a number of years to sort of pre-financial crisis times, and when Margaret Cole and Tracy McDermott were in situ, the tone in tenor was often a lot tougher and it then softened for a number of years. And now it seems once again, with Nickel, Rafsay and Moxie, that the tone is actually getting a little bit firmer. And last year, the FCA stating that its enforcement approach is to make it clear that there are real and meaningful consequences for firms and individuals, and also to detect serious misconduct so that they can intervene and prevent harm from happening or continuing. Now, this is where I may be a little bit challenging and say I don't think actually either of those two things are probably happening at the moment. Certainly, if you compare current performance level with previous performance level of the regulator, and I think trying to demonstrate that there are meaningful consequences for firms and individuals against the backdrop of the number and the sort of level of outcomes. There are some very good cases, don't be wrong, there are good outcomes in some matters, but the level and the quantum of them, I think, is much lower. And I also wonder if there's a sort of slight crisis of confidence. That last statement saying we want to detect so that we can both intervene and prevent harm from happening or continuing. That sort of prevention is not actually an enforcement act itself. That is what supervision gets up to. And I just wonder if this is still a little sensitivity, or some of the criticism the regulators had in last year and actually the year previously in relation to matters such as mini bond type scandals, finance, and just not taking action early enough. And I have to say, I've not really seen any evidence either in terms of enforcement outcomes or in the matters that were dealing with, where very often threats are made of potential intervention, but little follow through actually happens in practice. Let's go on to the next slide. Now, in terms of what's going on within the enforcement division, one of the trends that you see is that actually more and more matters on the face of it are being investigated. So last year, the enforcement division opened up 194 new enforcement cases. That were cases that were being started in that performance year. And that was an increase of 55% on the previous year. Now, that in itself is perhaps not that surprising when we're sort of comparing a more ordinary year now to what was effectively one of the pandemic years in the year previously, where activity had really dropped off. But what we weren't seeing, and the figure's not here, is actually the closure rate is not increased either. And what seems to be happening is that actually the regulator is very comfortable with opening investigations into firms, but they perhaps don't go very far and or very quickly. And we can see this from some of the metrics in terms of how much time it is now taking for an investigation, and the average investigation is now just under 2.5 years, and 76 of the cases had been open for 800 or more days. Now, that is an awfully long time period for firms and individuals to be under investigations. And I think one of the sort of critical observations I'd make is, particularly for individuals, that is incredibly onerous and puts a significant burden on them. And if you consider how many investigations are commenced with how many outcomes are actually taking place, it means the very great majority of investigations don't actually result in an outcome. So presumably, either the regulator has not found anything that justifies enforcement action, or it's just ultimately progressed them far enough and then decided, even if there is some basis for an action, it's not proportional to take it. Now, that doesn't seem desperately fair or reasonable for firms and individuals to be subject to that cost and burden. And if we went back a decade or so, actually, you were probably shaving off at least a year on that period of time for investigations. Now, one could take a slightly different philosophical view and say, actually, if you're wanting to have a deterrent effect, one of the ways of doing that is opening more investigations. And in many ways, the investigation itself is the disincentive or sanction. So a regulator can be trying to say, well, you make sure you keep your socks well and truly pulled up, because actually, if you get subject to the process of an investigation itself, that is going to be distracting and very, very difficult process for your firm. I think those metrics are certainly mirrored by our experience. So Seb and I, for example, we've been doing an enforcement action in the pension sector, and it was a matter that actually another firm passed us to look after for them. And that case now has been running nearly 4.5, 5 years. And I have to say, it's not desperately complex in terms of the issues or the amount of evidence, but just the pace at which the matter had been progressed, both by and supervision, is exceptionally slow. And I think whilst that is a comment we're making in an enforcement sense, I think probably we've had a similar experience with other functions of the FCA. So if you're going to have interactions with supervision or authorization, say you've got a change in control type application, your business is making an acquisition, you've got to build in a lot of time just to allow that. And I think that's partly as a result of the fact that the staffing within the regulator has decreased. There's almost constant recruitment from the regulator at the moment, which they struggle to fill, and real challenges there for them are on resourcing. Now, again, in their annual report, they indicated a number of areas where they would be having current themes of interest. And whenever we hear current, again, that normally leads on to that's where we want to be looking for some activity. And you can see there, I'll let Seb and Sona talk about these in a bit more detail, but really market conduct, so the insider dealing, market manipulation, an area where the regulator has been particularly active on the financial crime and criminal prosecution side. That will continue. And actually, I think probably that bullet point has been a bullet point ever since 2001 in the establishment of the FSA. That's never changed. So not expecting much change there. One of the aspects which is slightly more novel is the ESG type disclosures, and regulators expressing concerns how firms handle those disclosures, and so-called greenwashing. Have to say that's not something which has come across our sort of enforcement desks as contentious lawyers, but we're very much looking out for those kinds of cases. And I think that will be one where, when the regulator identifies the right case, on the assumption that there is one there, that is where some activity would be pushed through the messages. As I've alluded to, pensions advice and pensions mis-selling, that is still huge within the regulator. They've got dedicated teams in supervision and to a lesser extent in enforcement, trying to handle a large backlog of pensions mis-selling cases. I have to say, that's coming to a bit of a grinding halt. One of the things we've seen in that area, though, is actually the enforcement and supervision team getting a bit of sort of battle weariness. And actually, if you are in an area where you may be subject to that important action, not normally something we'd be saying, but actually a battle of attrition, and if you can sustain your business, actually just keeping the case going could potentially result in successful outcomes with the FCA. So interesting there. And another one which has been active again over the past few years is this continuing and ongoing focus on financial crime system controls. We do a lot of work in the overseas banks sector, and sort of every year we see cases coming in that area. And also, I think we're going to see more in that area and perhaps fintech sector over the next few years as those businesses scale up as well. If we move on to the next slide, please. Then, as I said, slightly top of the pop style, how has the regulator actually performed in terms of its outcome? Well, actually, if we do a sort of year-on-year, it looks on the face of it that the FCA has become more active in that when it's financial penalties against individuals, there were only 10 in 2022, 3 in 2021. But you could compare that back in 2013 when there were 20 outcomes. Now, I find this really quite interesting, given all of the focus on individual accountability, implementation of the SMCR, that actually you see very few actions against individuals. Is an interesting message. Now, there could be a number of reasons for that. One, I think, is most definitely an aspect of enforcement activity levels. And one of the things I had a slight wry smile at is that actually, if you were to look on the FCA's website now, it's always kept its fine data publicly available, but all of it pre-2013 now appears to have vanished. Because if you went back to 2008, 2009, 2010, actually you would be seeing years where there were 50, 60, 70, even 80 actions against individuals, and similar sort of increased level of actions against firms. So the actual quantum of enforcement outcomes through final notices has really dropped. Now, some of that might be reflected by the fact that the SMCR regime has also put more emphasis on firms taking disciplinary action. So more of that kind of work may be dealt with now through that route, but that's hard then to assess in terms of what's happening. Then in terms of the total number of financial penalties, again, going up from 26 to from 10 in 2021, but again, compare that with 48 in 2013. So it looks like there's a bit more activity, things are perhaps normalizing, but still not at any particular high level. And then just to get a feel of the scale of where financial penalties are imposed at the moment, from the FCA, financial crime case, Santander, 107 million. So that's quite a chunky figure there. Smallest fine, again, going back to that pensions mis-selling type sector, the chap called Tristan Freer, who was involved in that. There's also a little light misleading of the regulator there. And again, reflecting that he was not a desperately highly paid individual, a 42k fine plus prohibition order. One of the points I just make, though, from coming out of all of this on the individuals, again, is that every single individual enforcement action was based on the Code of Conduct for Approved Persons APA, rather than the much more modern SMCR Code of Conduct for COCOM provisions. Now, again, considering the messages around individual accountability and the fact that we've seen hardly any COCOM enforcement case, it does just raise the question of, well, how much are we ever going to see, and are we going to realistically see much of that next year or the years coming, particularly when following sort of the Rishi Sunak appointment as Prime Minister, there have been various comments around, we're looking at SMCR and COCOM, and is it sort of too onerous? And so too onerous when you don't see any outcomes at all? That's quite interesting. Then just finally, one of the final things I pulled out of the annual report is actually the use of skilled persons. Now, strictly, this is not an enforcement tool, but I do think it's really important because I think it's one of the most likely areas where if a firm has difficulty, they may have a more what I describe as formal interaction with the regulator. Now, skilled persons are very intrusive and actually very costly. And I always think, slightly cynically, one of the real motivations for the FCA to use this tool is actually it can enable them to get a fairly decent review or investigation into a particular firm, but effectively subcontract it and get the costs off of the regulator's balance sheet. Now, what we have seen actually is a reduction in the use of skilled persons. I think that may be mostly due to the fact that those skilled persons were being deployed very, very heavily, again, in the sort of pensions mis-selling sector by quantum of appointments. And because that work stream now is still running and has got a lot of work, there aren't the new appointments that we're seeing. But if there were to be an area, particularly in the retail markets, where a more widespread review was necessary, I could certainly see that very swiftly going back up again, because I've seen no sort of lack of appetite for that as a particular tool. And then you can just work out yourself on a sort of average basis. If there was 38 appointments and the average cost of firms was 37 million, that is a chunky cost, especially if you are a smaller firm. And I think that takes us on to the next section. And I'll hand over to Sona.
Thanks, Peter. So as Peter said, I'm going to be doing a bit of a deep dive and looking back over the enforcement decisions that were made by the FCA and the PRA over 2022. There was a real range of cases, particularly towards the latter half of the year. We saw a flurry just before Christmas, but they largely focused on three main areas. Next slide, please. And so those three main areas were financial crime. And here we're talking about the whole range of financial crime, so from money laundering and including bribery and corruption. The second one was market misconduct. And again, I'm talking about that in the sort of broadest terms, so from transaction reporting failures to implementation failures. And finally, governance. Now, really, that's a theme that's sort of run through all of the cases, but I thought it was quite important that we discuss it and bring out some of these issues separately, and particularly in the action that the PRA has taken last year as well. So rather than summarise the cases, because we could be here quite some time, what I thought I would do is just draw out some of the key takeaway points that have been made by the regulators in those cases. And so those things that, practically speaking, you should be thinking about within your firms and thinking about how does that impact your sort of what you're going to do within your businesses going forward. But of course, if anyone's got any specific questions on the cases that they'd like to discuss or raise, do feel free to put that in the question and answer function on your screens, or you can feel free to sort of pick up the phone later on and I'd be happy to talk those through. So next slide, please. So I'm going to start off with financial crime. And really the key to remember here is that the FCA sort of continued its focus, unsurprisingly, on money laundering. And that's following its sort of the back of its success in 2021 with NatWest. So the FCA took a range of action. And it took action against 4 firms and an individual. So there was 3 banks, an interbroker dealer. And we finally saw the response in relation to the CEO of Sonali Bank. And before I go into the takeaways and what themes sort of came through those cases, I thought it was important to raise a sort of general point of interest here. Now, in all of those cases, there was no real evidence or actual evidence that any money laundering or criminality had actually occurred. Now, that's not new. Of course, we've seen the regulators take action before. But what I thought was important is that there's still a real uncertainty as to how the FCA is going to approach cases of money laundering. Now, I'm sure if you've delved into one of these sessions before, you'll know that I've mentioned before that the FCA's it can really take these cases 2 ways. So it can either use its powers under the money laundering regulations, where it has both civil and criminal powers, and it can pick up on specific breaches of those regulations. Or it can treat the case as a purely regulatory matter and focus instead on principle and rules breaches within the FCA handbook. Now, again, in 2022, it did both. And so in 2 of the cases, it approached it under the money laundering regulations and took civil action. And in the other 2, it focused very much on principle 3. So that's having adequate systems and controls, or principle 2, breaches. Principle 2, of course, as a reminder, is acting with due skill, care and diligence. Now, unfortunately, it's not really clear with those cases, given that actually the facts were quite similar between them, why the FCA approached it in this way. But hopefully what I hope to see in 2023, and Seb will pick up on this later, is that sort of approach of the regulator will become clearer in coming years. So I'm going to turn now to the sort of common factors and themes that were running through those cases. So what was the FCA really concerned about? So looking at the cases, there were really 6 key points to take away. The first one is having clear and accessible policies and procedures. And by that, I mean, what the FCA was saying is it's great that all these firms have suites and huge amounts of documentation about how to approach money laundering risk and onboarding. But the difficulty is that in some cases, and Ghana International was a good example of this, is that those policies are fragmented and they're owned by different parts of the business. And what's happening is that they're being updated at different points in the year, and there's no cross-referencing between them. So that creates a bit of a minefield, because those at the front line who are meant to be carrying out these checks are actually not able to work out what it is they're meant to be doing. So that's a really important point. Make sure that your policies, wherever they are accessible, they're easy to find, and they're easy to understand. Second is onboarding. The FCA, in all of those cases, really focused on inadequate onboarding checks and the real need to have robust onboarding procedures. So here we're talking about failure to carry out risk assessments and categorize clients, the failure to really verify and check up on information provided by clients and also other parts of the business. And that has a knock-on effect on enhanced due diligence procedures. So the requirements as to when enhanced due diligence was triggered was confused in all of the cases that the FCA focused on last year. So to give you a bit of colour on that, Gatehouse Bank was an interesting one because there actually the regulator said the bank went above and beyond what was required by the money laundering regulations, because it was actually saying in its policies every single client, regardless of how it's being categorized, has to provide information on the source of their funds. Now, part of that was because of the risk it saw inherent in its business because of the jurisdictions of where its clients were. But what happened was, because of this sort of inconsistency of approach within the documentation, it wasn't really clear when those at the front line had to ask for that information, what they had to ask for, and what sort of documents they should be relying on. So that inconsistency led to risk. A second example is Santander. And there, what the regulator was focused on is that although Santander had recognised that a risk for its business was taking on clients that were money service businesses, and actually on its documentation it said we were only prepared to take on one. In reality, because it wasn't actually appropriately categorizing its clients, it had multiple money service businesses across its business, and it just didn't know. And it was only when it was going through a review with the FCA involved that it realized it actually had a number of them on its books for many, many years, and those clients weren't being monitored. So third, poor record keeping and categorization meant that firms aren't actually monitoring and carrying out those periodic reviews. So it's that point around Santander again. So if you do have high risk clients, if you're not appropriately recording them, you're not going to then trigger other parts of your policies, which leads to periodic reviews, monitoring of those clients and taking action against them if there are difficulties. So that's really where this sort of the risk of a principal tier breach comes in, because it's great that you've got these systems and controls, but if you're not implementing them correctly, the risk is the FCA will say, well, you don't approach this with due skill, care and diligence. The next theme is around investment and resourcing. Many of you are going to be familiar with this. It's come through on cases for a number of years now. But what the FCA was honing in on is if you don't have enough manpower, if you don't invest in training, then what happens is that leads to an increased risk of not following the procedures correctly, a lack of challenge and a delay in responding. I thought it would be helpful just to sort of bring that delay point out, because in Santander, for example, whilst they had undergone a huge transformation following previous concerns raised by the regulator, they hadn't quite resourced the teams appropriately. So there wasn't real ownership of money laundering risk within the business bank. And what happened is that although flags were raised because the policies were kicking in, those flags weren't actually actioned. And in some cases, flags were sat on people's desks for many, many months before any action was taken. And in one case, a whole year had passed before bank actually responded and took action in relation to one client. And in Gatehouse, it was interesting because the compliance function had raised for over 2 years that it needed more resources, and those messages were really going unheard by senior management. A word of caution, though, because although training came up and lots of firms have training in place, the FCA said, don't rely on standardized online training. It didn't think that was adequate because the focus should be on bespoke training for your firm. So that means picking up on training that actually uses real life examples that are going to be faced by your business, but also really looking at training in different ways for different parts of your business. So your frontline staff might require some form of training, and that will be different and should be different for those at a more senior level, operating at a sort of more from a governance perspective. And what the FCA said there is that it's not going to be an excuse for personal culpability if you're not trained adequately. So the former CEO of Sonali Bank, one of the points that he had made in his defense was that I didn't appreciate what the actual requirements were, so I wasn't then able to respond and provide the resources that the compliance function needed. And the FCA there said, well, actually, it was on you and it was incumbent on you to make sure you get appropriate training. So that was quite an interesting point that came through. And finally, the final sort of 2 points that came through was historic compliance failures. So if you've had the regulator knocking on your door before, either through a Section 166 process or actually through enforcement action, if you then don't implement and make changes that have been raised by those concerns around weaknesses that have been spotted, the FCA is going to not be particularly pleased if those issues come up again. And in a number of cases where there had been historic failure, that actually then fed into the penalty that was ultimately levied against those firms. And finally, what was interesting is that the FCA criticised a number of firms for saying, well, you've not actually asked or read and thought about guidance that have already been given by the regulator. So it's really important that you keep on top of any of the reports that come through the regulator, the Joint Money Laundering Steering Committee's guidance, the Financial Crime Guide, and of course, enforcement action that's been taken already. So if there's a takeaway here, it's read the cases. And finally, I'm just going to pick up in relation to bribery, because interestingly, there were actually 2 cases that the FCA took that involved bribery and corruption. One of them was the Julius Baer case that's mentioned there, and the other one was against JLT Specialty. They were quite interesting cases and quite complex, so I don't really want to focus so much on the facts of them. But what's important here is that there were really 4 key lessons that came through. The first one was making sure firms carry out a risk assessment of their own business. Now, we know about risk assessments, you'll be familiar with them, and many of you will be doing them regularly anyway. But the point that was interesting here is that the regulator said, when you have financial crime policies, particularly around bribery and corruption risk, that are handed down by your head office or other parts of the business, they may not be appropriate for you as a regulated firm in the UK. So it's really important that you, when you're implementing those policies and procedures around bribery and corruption, that you're thinking about how those apply and whether they meet your specific risk within the UK. So it may be that you need to push back against head office and say, well, this might work there in your jurisdiction, but it doesn't work here, and actually our standards are different. So that really came through in the JLT case, where actually other parts of the business in Colombia, for example, they were conducting particular risk assessments, but that didn't really apply in the UK. And it was incumbent upon the UK entity to push back and say, no, that doesn't work here. The second point, which sort of I thought was interesting, is that the FCA were really quite harsh and saying, well, actually, we need to be notified immediately if concerns around bribery and corruption and financial crime generally are raised within the business. So this, I think, is going to be something that we all need to think about going forward, because in Julius Baer, it became clear that a whistleblower within the business had raised concerns, and actually the bank didn't act on that, or the organisation didn't act on that for a couple of months. It then got an external firm to come in to carry out an investigation. But actually the firm didn't tell the regulator until some 18 months later. And obviously that's a huge gap. And we can see that that would be problematic. But what the FCA said is that it expected to have been told as soon as that whistleblowing allegation has been raised. Now, that's interesting because we've always talked about, there is that fine line between concerns being raised within the business and actually being able to investigate or trying to at least work out whether there is a concern or not. So that's just something to flag. And the third point to remember, and again, it's a bit of a technical one, but I think it's an important one to think about, is that when knowledge or misconduct on the part of one individual in the business will then translate into liability for the firm. Now, we all, without going into the detail of it, we know that there is this concept of directing will and mind of a company. But in Julius Baer, interestingly, what they said was that the actions of a fairly junior employee who was embroiled in a sort of conspiracy with others to take bribes, it was her knowledge that was attributed to the firm, and therefore the firm was held liable and was found guilty of a Principle 1 integrity breach, which was quite an interesting case, and it was clearly one that had been debated by Julius Baer and by the regulator. But the authority just said, no, in this circumstance, we're taking a sort of case-specific example here, and we're going to say that her knowledge and intentions are attributable to the rest of the organisation. So I think, again, the point to think about there is that it's not just the actions of the senior managers you need to be concerned about, it's also those at a more junior level when it comes to financial crime. Next slide, please. So turning to misconduct and market misconduct. Now, it was interesting because actually this was quite a large focus area for the regulator last year. And it's great because there was lots of cases, but they were all quite specific. So what I thought I would do is just pick up on 3 key points here. The first one was ineffective transaction reporting or inadequate transaction reporting. And the key messaging here is not really surprising. The FCA has been talking about the importance of data, and Peter mentioned it right at the outset of our session here, that in order to prevent harm going forward, it needs to be able to monitor the market, and a critical part of that is receiving stalls, so suspicious transaction and order reports, so that if there is any suspected market abuse, then the FCA can step in and take action, and that's a critical part of what they do. So making sure that you as a firm are really on top of your transaction reporting requirements and what they mean, and actually looking at the quality and quantity of the reports that are actually made to the regulator. And the reason why I say that is in Sigma Finance, the regulator did pick up on the fact that over the course of the relevant period, that the organisation didn't make a single report to the FCA, and that in itself was sort of indicative of failures within the business. And the second one is the importance of timely and effective implementation of legislation. So this isn't actually important just from a market misconduct perspective, it's more of a general point, which I thought was important. So in Citigroup and in the GFI cases, what had happened is that the organisations hadn't actually properly implemented the updates to the market abuse regulation. So they didn't really appreciate the new requirements in terms of monitoring. And the important bit there was that the FCA was saying, look, you need to know what's coming through, you need to do some horizon scanning, and you need to make sure that you've given your organisation adequate time to implement the changes that are required. And the flow on from that is the third point I wanted to pick up, is making sure there's appropriate senior management oversight and supervision of any projects that are ongoing, and making sure that you understand what is actually being implemented in your business and whether those implementations are on track so that you're not in breach. So I'm just going to move on to the next slide now. So this is around governance and culture. So as I said at the outset, this was actually a recurring theme throughout the whole year in all of the cases that was taken by the FCA and the PRA. But I wanted to pick up on it as a separate point. And I think that at its heart, there were 3 main things that I think are important to take away. The first one is investment in the second line, because what we've seen is when you don't have appropriate oversight and supervision, you're not going to be able to implement and follow the regulatory requirements appropriately. So senior managers really need to invest in their compliance function, and that I think will continue, we'll see as a theme throughout following years. And the second point is making sure that actually you're not overly complicating your reporting structures and within the business. And so there it was interesting because in Santander and in Julius Baer, the regulator was really focused on very complex matrix reporting structures. And what that meant was that there was an increase in the possibility of financial crime and market misconduct, because actually it meant teams were working in silos. They weren't actually getting appropriate sign-off and approval by senior managers within their own business. They were actually going to other parts of the business because of the way the reporting lines worked, which meant that senior managers were approving decisions that actually they weren't really fully appreciating because it didn't impact their day-to-day work. And again, this came through on the individual cases that the regulator took, particularly against the executives of Sigma and of Sonali Bank. And all of them were personally criticised for not taking ownership and putting in place adequate governance procedures. Now, I know we've talked about, and Peter mentioned before, we've not really seen any cases come through on the SMCR yet where we're thinking about personal culpability. But actually, the cases that did come through under the old regime in 2022 are really picking up on that theme around governance and personal responsibility. So maybe it's a sign that we'll start seeing more of that perhaps in coming years. And the final one really was around outsourcing and governance generally. So this is where I think it would be interesting to look at the PRA's response. If I can just turn to the next slide. So the first one I'm going to pick up on is the case against TSB Bank. So this was actually a PRA and a joint PRA and FCA decision. And it was interesting because it picked up on operational resilience and outsourcing, which is something that obviously has been a theme for quite some time, but we really saw it come through in this case. So I won't go into the facts of TSB, but it was a sort of well-known matter that it had suffered a sort of a significant IT failure. And what both regulators were really talking about there is that if you are going to outsource, it's really important that you adequately carry out risk assessments on your suppliers and on your outsourcing arrangements so that you make sure you get the right firms working for you and that you understand how they're going to implement any changes, and really making sure that you're continually assessing what those outsourcing firms are doing. And the next one was on MS Amlin. So this was a really interesting case because it was in some respects a sort of pure PRA enforcement action that was taken. And the trigger really was at that time it had undergone significant transformation and then found itself having sort of questions over its capital adequacy requirements because it had gone through sort of severe financial difficulty. So what the PRA picked up on there, which I think is really interesting, is its focus on the culture within the organisation. Because what they said was, although that you'd gone through, MS Amlin had undergone significant transformation, what it had failed to do was embed a strong risk culture. And what that meant is that actually there wasn't appropriate ownership of risk across the business. There wasn't the clear response to remedying weaknesses within the business that had already been identified through previous Section 166 reports and previous regulatory intervention. And what that meant was that permeated across the whole business. So that meant that there were risks being taken in the front line as well as at other parts of the business. So I think we'll go and see more of that coming through. And again, that was some of that theme was seen in some of the FCA cases. But I think this will come up through later on when we see cases come through the next few years. I'm going to stop there and hand over to Seb, who's going to talk about what we're seeing going through in the next year.
Thanks very much, Sona. Well, I've probably got the easiest job because this is just a bit of kind of, as Peter said, crystal ball, mystic, meg gazing, and probably by the time we do this next year, you'll have forgotten what I said, and then I can come back, as Peter said at the beginning, and say, look, we were totally right along with our predictions. So we can move on to the next slide, please, Eva. So we're going to have a look at just a few potential predictions. So perhaps some consumer duty cases on the horizon, more financial crime cases, not much of a surprise, and some SMCR conduct rule breach cases, and potentially some changes to the SMCR that Peter alluded to earlier. And also, let's have a bit of a think about the impact of FCA personnel changes. So if we can go to the next slide, please. So the consumer duty. So as I'm sure you will know, in July of last year, the FCA announced that it would require regulated firms to adhere to a new consumer duty. And this duty obliges firms to deliver good outcomes for retail customers. And the aim of the duty is to improve standards of consumer protection across financial services. and the firms to put their customers' needs first. You may be thinking it's perhaps quite similar to the existing obligations under Principle 6, which has been around for a long time, which require a firm to pay due regard to the interests of its customers and to treat them fairly. But nevertheless, we have a new consumer duty. It's being phased in various stages, and the first phase of implementation comes in from the end of July of this year. But as again, I'm sure you know, firms were required to agree their implementation plans by the 31st of October last year, and provide evidence such as board packs and minutes to the FCA to show that they've scrutinised and tested those implementation plans and that they will actually work. The FCA's business plan for this year was very clear, as Peter said, that the FCA were looking to take quick and effective action and to act assertively. And the policy statement on the consumer duty made it clear that, I'll just quote it, by embedding the duty in our approach to authorisation, supervision and enforcement, we'll also increasingly focus on the outcomes customers experience. This combined with our more data-led approach should enable us to intervene more quickly when we identify practices that negatively affect customer outcomes and more assertively before those practices become entrenched as market norms. So again, that theme of early intervention. We know from an associate that's joined our team at the end of last year that this specific area is very much on the FCA's radar for the latter half of this year. It's a new shiny thing. And I wouldn't be at all surprised if we see potentially some investigations, not published outcomes, but investigations towards the latter half of this year. The FCA already have the business plans or the implementation plans of the firms. They're likely to know where the potential problems are going to be, and they may well be straight on top of those firms in the late summer, autumn, if they haven't properly implemented. So I'll make sure you're not one of them. Next slide, please, Eva. So more financial crime cases. Sona's talked a bit about the various financial crime outcomes we've had of last year, and in early January this year, the FCA gave two late Christmas presents with a £7.6 million fine for GT Bank and a £4 million fine for our Ryan Bank, both for AML failures. And one of the things I think that was kind of apparent from those outcomes was that there had been historic failures at both institutions. For GT Bank, there was a 2013 fine levied by the FCA for exactly the same thing. There was in 2018, Section 166 skilled persons report around AML failures, and they hadn't resolved the issues that the FCA had identified. And similarly, there was for our Ryan Bank, there was a voluntary restriction of their business, but they hadn't resolved the issues that the FCA had spotted. So if you do have those issues, make sure that they're sorted, because otherwise you'll come back with a nice chunky FCA enforcement notice. And just touching on the points around money laundering regs, I think it's perhaps useful to think back to NatWest and the difference perhaps with that case, and why it became a criminal case under the money laundering regs was because there was substantive money laundering. And in that case, it was a corporate customer of the bank, and whose staff were eventually prosecuted for substantive money laundering. And the corporate customers, the staff were bringing in big bags full of dirty cash into branches, and flags weren't being triggered, and when they were triggered, they weren't being properly heeded. So if there's any evidence of substantive money laundering, that's the risk that you potentially face a criminal prosecution. We're definitely going to see more of those cases over this year, to make sure your houses are in good order. Next slide, please. More SMCR conduct rule breach cases. So this is a question that we had in the chat that's probably easiest to deal with now. The question was, what does no SMCR cases yet mean? Surely SMCR individuals have been investigated. Doesn't mean that no case has gone to court. The been given public conclusions. Yes, that is what it means. So just a bit of a recap. These rules have been enforced for banks and insurers since March 2016, and for solo regulated firms since December of 2019. So a fairly long time, certainly for banks. Despite this, we've only seen one case that has been published, the Jez Staley case, CEO of Barclays, for trying to ferret out a whistleblower. And he was found to have breached COCOM Individual Rule 2 and was fined £640,000 odd, jointly by the FCA and PRA, but wasn't prohibited. And that remains the only case, the only enforcement notice for breaches of the conduct rules. Of course, COVID's happened in the meantime, so it takes a little time for these cases to come through. Lots of the FCA cases we're seeing are fairly historic, and I think more of these cases will start to come over the coming years. There was a FOIA request from late last year, which said at the end of 2022, the FCA had 50 senior managers and 16 certified persons or members of conduct rule staff under active investigation for these breaches. So actually, in the grand scheme of regulating nearly 30,000 firms, it's really not very many at all. I think that number is going to increase. We've recently started an investigation representing a former senior management function holder for breaches of COCOM rules. So we should be able to give some good first-hand insight at this talk next year. Next slide, please, Bill. So changes to the FCR, to the SMCR, it's not really an enforcement topic, but it obviously has such a big overlap with enforcement. As Peter said, perhaps why we've seen fewer of these cases is because firms have become effectively their own regulators, their own enforcers. So it's useful to touch on this. In the kind of well-known about Edinburgh reforms announced at the beginning of December, the government said they were going to include a review of the effectiveness, scope and proportionality of the SMCR. So what does that actually mean? The government said it's going to be in two parts. They said it's going to be in the first quarter of this year. The first part is going to be a call by the government for evidence on the legislative framework of the regime, its scope, its effectiveness and its proportionality. And they'll seek views about potential improvements and reforms. Secondly, the FCA and the PRA are going to review the granular framework of how the regulations work. So this is probably going to be much more detailed, and if anything is going to lead to change, it's probably their work, not the government's. It's obviously an important area, and firms are going to look at this very closely. So it's worth watching out for those and potentially thinking about contributing if you have the time and the inclination. I think it's going to be probably a relatively slow process. It's been looked at several times before. The regime's only 7 years old. Both the PRA and the FCA undertook reviews. The FCA in 2019, the PRA in 2020. Neither resulted in changes being made, but both regulators just said, look, the SMCR is very successful, it's improved culture, and it's driven up standards of conduct across the industry. We like it. So if there's going to be anything, it's probably going to be a kind of evolution rather than a revolution of the regime. Potentially some targeted relaxations, something like a relaxation that's quite similar to core firms as opposed to enhanced terms, potentially. Next slide, please. So the impact of FCA personnel changes. So it was announced there's obviously been a lot of change since Nicole's taken over, and kind of publicly, the main public message is we want to be a data-led regulator. And it has seen a lot of change. In mid-October, it was announced that Mark Stewart, Director of Enforcement, is going to be leaving this spring. His departure is not necessarily unexpected. He's been at the FCA for 7 years, and he's made a significant amount of changes. Perhaps more personally, he was only one of 2 executive team members who have remained in post since Nicol took over. So it does seem to be arguably a bit of a cleaning of house. His successor hasn't been announced. Who knows whether it will be an internal promotion, and there are a couple of names that we can think of, or maybe an external hire. Mark brought about very significant changes in enforcement, most notably a significant increase in investigations, and it's reasonable to think that a new director is going to want to make their own mark. Secondly, in terms of kind of general resourcing issues, and Peter's touched on this a little bit, it's been fairly well reported in the press that FCA, the FCA generally, and also enforcement, isn't a particularly happy place to work over the last few years. There's been strikes by the FCA staff, lots of people are leaving for private practice. As I said, we recently had someone join us again from the enforcement division. The FCA offered as a large-scale voluntary redundancy exercise last year, significant changes to senior staff pay, and it's reasonable to think that more are going to leave, which perhaps makes for a bit of an unpredictable enforcement environment. Potentially, you're going to get more junior, more inexperienced staff members on your cases if they're in enforcement wanting to kind of make their mark or be a bit ambitious. So I think being a bit cautious of that. And what I would say is, if you have someone that seems to be sensible and you can deal with matters proactively, it's probably worth trying to advance things with them before they leave, and you get someone else who may be not the same. So I think that is all I wanted to say. That's probably a bit of a whistle stop tour through what we may see this year, and we've got just a couple of minutes left for questions.
Thank you, Seb, and thank you, Peter and Sona. Just briefly on the Edinburgh reforms, I agree with what you said, Seb, about the SMCR things. We're expecting a D&I paper from the 3 regulators, the bank, the PRA and the FCA, and I'm hoping that there'll be some guidance in that on what they mean by and when they're likely to take enforcement action on non-financial misconduct. If only because we see in the market is that those things are working out so unfairly. And when we've seen SMCR type cases being brought, the regulators have been criticised so heavily by the courts and the tribunals. So some clarification there might help. But as you say, I think unlikely that we'll see any significant relaxation. And we've got time just for one question, I think, and I might just put this to all of you. I don't know whether you would have seen yesterday in the papers a report that the government's planning to introduce a new offence, which would be an offence in connection with the prevention of financial crime, mainly I think aimed at lawyers and accountants who the government's determined to enable these things, but likely I think to have an impact on others. I wonder what you thought about that.
Yeah, I'm really always very skeptical about these kind of things, mainly because it's very easy to put these type of offences on the statute book, but unless you've got anyone to actually police them and enforce them, then they're kind of a bit pointless. You're really just expecting businesses to kind of take it upon themselves. But we've had for some while now failure to prevent tax evasion. No prosecutions for that whatsoever. We've got failure to prevent bribery, numerous problems with the SFO, and these agencies don't have budgets to do this. They're not properly resourced, and it will be, the point will be, who is going to do this? Will it be the FCA? I'm sure the FCA won't want to be the kind of main enforcer, policer of this at all. So I'm highly skeptical of these things.
I'll just jump in on that as well, because I think it's an interesting one, and I can see the difficulty, because one of the things, and I sort of touched upon this earlier, and we could probably do a whole session on it, it's really difficult for regulators and prosecuting authorities to take action against firms for when there has been financial crime that their employees have been involved in, because it goes back to this point of how do you attribute the knowledge and actions of your employees if they're not necessarily at a senior level to the organisation. And I can see why, one way around it is to think about these sort of failure to prevent type offences, because it makes it easier to prosecute and to take action against firms. But I agree with Seb. The real difficulty is that we've had these before. We've seen it with the bribery and corruption. We've seen it with tax, and it hasn't actually had a material impact so far. And so I think whilst I can understand the difficulty, I can't see how it will work in practice.
It's interesting, isn't it? It's almost back to Peter's point at the beginning. The risk isn't enforcement action, and in most cases, the risk is supervisory attention, which wastes so much of your time and money that in some cases we've seen in the last year or two, actually, they waste so much time and money that they kill the business.
Absolutely.
Unfortunately, which must be wrong, but there we are.
I'm just going to say on that last point, Chris, it's totally echo what Seb and Sona say, but the reality is, even under the Proceeds of Crime Act and general obligations to impose effective controls for money laundering prevention, many of those are backed by various criminal provisions if you don't take those steps. And so it's another one of these. It's not that there's a lack of power already in order to tackle these issues. If those issues are identified, the powers are there. I actually think it's the resourcing and expertise to bring the cases, which is why we're seeing the sort of metrics that we're seeing for the regulator at the moment. The reality is, if you want really effective law enforcement in whatever area of life it happens to be, whether it's financial services or otherwise, you've got to resource it. And if you don't resource it, the cases can't be brought, because actually a lot of these things are quite tricky and time-consuming.
Thank you. Thank you all. We're out of time, so thank you to each of you for from your comments this morning, your insights, your predictions, and thank you to the audience for joining us for your questions. We look forward to seeing you again in 2 or 3 months' time for our next forum.